some big news about the United States Supreme Court taking on a case out of Mississippi that deals with the abortion law. What essentially happened was the state of Mississippi's legislature passed an abortion law, and a lot of states have been doing this, that actually doesn't fall in line with the prior case law that exists, that being Roe v. Wade and Planned Parenthood versus Casey, these prior cases that sort of set the standard for the legality of abortions and where they will go, what will be permitted and what won't be permitted. So other states have now passed laws that differ from these prior standards. Roe v. Wade was in 1973. Planned Parenthood was 1992 or 93, I think, and where the Supreme Court sort of set the standard there. And so now recently the Supreme Court agreed to take on this Mississippi case. Now that's really, really significant. But for me as a lawyer, there's another aspect to the Supreme Court taking this case that I find extraordinarily interesting. And that aspect is, what is the Supreme Court's role with respect to laws and making law or deciding what's proper law and what's not? And you have to go all the way back to 1803 to probably the most important constitutional case that ever existed, a case called Marbury versus Madison. The Supreme Court, one of the most famous constitutional quotes, said, "It is emphatically the province and duty of the judicial department to say what the law is." So in 1803, the Supreme Court saying it's us. We get to say what the law is. State legislators could pass laws, but ultimately it's us that get to decide what is and what isn't constitutional. In other words, what is and what isn't the law. That's really, really important, because then in 1973 and again in 1992, the Supreme Court weighed in on what they believed was or wasn't constitutional with respect to abortion. Simply by deciding to take this Mississippi case, where the Mississippi legislature now passed a particular law that differs from what the Supreme Court said is the law in 1973 and 1992 with respect to abortion, we now have the United States Supreme Court saying they may decide once again what the law is. That's really significant to a lawyer, because as an attorney, we look at the Supreme Court and all of the higher courts and we say for guidance, and we say, well, we need to know what the law is. So we look at precedent. So once precedent is set, we have an idea as lawyers as to what the law really is. There's two types of law. There's common law, which is the case law that the courts interpret and say, and then there's legislative law. So here we have the United States Supreme Court really setting the standard with respect to abortion in two very landmark seminal cases. They're using the power created in 1803 by the founding fathers themselves in Marbury versus Madison and saying, this is what the legal standard is. This is what the precedent we're going to create. So if you're going to revisit that now, which they are, it's going to be really interesting as to whether they will continue to adhere to what we as lawyers all believe exists, which is we follow precedent as to know what the law is, or whether they'll do something different. And obviously, a lot of people feel if they do something different, that has a lot more to do with political reasons than it does with the rule of law. Because the rule of law, you can look back in 1973 in Roe versus Wade and 1992 in Planned Parenthood and say, you guys have essentially weighed in on this. So this is really, really interesting to watch, obviously for the substantive reason of what they're going to say with respect to abortion, but also for the procedural reason. And for a lawyer, that's really as significant maybe as the abortion issue itself. In other words, do laws change because of who's sitting there and interpreting them, or do they follow suit along with precedent over years and years and years? So we have an idea as we move forward of what the law is. Extremely interesting situation brewing.